Good morning, folks. This is Gordon Dixon, the CEO for the Associated General Contractors of Virginia. I want to welcome you all to the first of a three-part series that we're conducting this week, next week, and the following week to help our members and those in the construction industry understand the implications that they're addressing at this point. Today, we're talking about keeping the project going, helping employees work safe on the job site and avoid delays. Today with us, I'm pleased to introduce our panelists of three attorneys from the law firm of Miles and Stockbridge. Miles and Stockbridge is a firm with offices throughout the Mid-Atlantic region. They have more than 220 lawyers help global, national, and local emerging business clients preserve and create value by helping them solve their most challenging problems. Its construction industry team represents general contractors, subcontractors, owners, suppliers, sureties, and all aspects of construction law, including contract drafting, negotiation, mechanics liens, bid prospects, and the litigation, arbitration, and mediation of construction claims. Before I introduce our panelists, let me go through a couple little logistics. Everyone is in mute mode at this point, and as you move your cursor around and you have a toggle bar. If you have a question, please hit the Q&A and type in your question, and I will read those questions out to you. We'll read the questions once our panelists present, and so in case those questions are answered during the presentation, we'll go forward from there. So let me start off by introducing first Susan Decker. Susan is a principal and co-leader of the firm's labor and employment practice. She represents businesses in all aspects of employer-employee relations. Her experience includes defending employers in matters including wage and hour issues, discrimination and harassment, family business leave, or family medical leave, and ERISA denial of benefits. Tom Wolf heads the Richmond office of Miles and Stockbridge and co-leads the construction industry team. Tom is a longtime AGC member and has represented contractors for more than 40 years, has taught construction law at the University of Richmond Law for more than 30 years, has authored many books and articles on construction law, has been lead counsel in countless construction cases, and is former chair of the Virginia Bar Construction Law section. Jessica DeHoffman is our principal and co-leader of the firm's construction industry team. She practices in the area of commercial and business litigation with a focus on construction law, mechanics lien, and bond claims. Jessica is an experienced litigator at both the trial and appellate levels in Maryland, New York, and District of Columbia. Without further ado, Suzanne, I'm going to turn it over to you at this point.
All right, thank you so much, Gordon, and good morning to everybody. If you could go to the next slide. All right, so our presentation today really applies to anyone who's in the kind of ramp up phase to start working or has already had employees on job sites working. The issues really are the same. As you know, the employees that you have often are your greatest asset and your greatest liability, the costliest item that you're going to have. And keeping it safe and keeping it working is a very important part of your business. So I'm going to take the people portion of it, and Tom and Jessica are going to take really the true kind of construction spin on it. So next slide. Next slide. All right, so how do we get people to work and how do we get them to work healthy? I think that's probably an important thing for you as the employer, but it's also important to your employees. And there's a lot of different things floating around out there and different ideas about how you can make sure that the people are healthy who can come to your job site. No one is going to be able to tell you that they are certain that in the moment they step on the job site that they are corona free. Or if they've had corona, maybe they could tell you they have the antibodies, but we don't even know what that means. The science behind this is still kind of a moving target. So what should you be looking at from your employees to make sure that people are safe when they're coming there and you lower the risk that they're going to infect others? So some of my clients are taking employee temperatures, and they do this in a number of different ways. They use a standard thermometer like you or I might have at our home. They use a temperature gun, or they use something that you can place on your forehead to see whether you have a temperature or not. They interview employees. That's another way to do it, is to ask what type of symptoms you're experiencing. Some have been talking about certifications for their employees to make sure that the employees are not saying that they have any symptoms, that they are certifying that they aren't. Another important piece to think about is it's not just the employees that you may be asking these questions to. You may also be asking them to customers who are coming on site, vendors, et cetera. And I can tell you, while all of our health issues seem to be on the table these days, there's a whole new meaning to how's it going, how are you feeling? I think we used to mean it as sort of a social pleasantry, and now everybody's medical information sort of seems on the table. Next slide. So when we're talking about these health screening, who's going to be responsible for it? So are we going to have an employee whose sole job it is to make sure and take employee temperatures when they come to work? I mean, that's an important thing to think about. Are you going to be able to get the equipment that you're going to need if you decide you're going to take temperatures? And if I'm screening you and I take your temperature, how close do I have to come to you in order to take that temperature? So I think all of these things, as you're planning and putting something in place, you need to be thinking about that. I think for many of the reasons, that's why many clients of mine have decided to go to the certification process, which is having a policy in place that makes sure employees know that they shouldn't be coming to work if they're sick, but asks them to affirm that they are not suffering from any symptoms before they get to work. You know, some clients of mine have said, what if we just have everyone take their temperature at work before they come to the work site and they can affirm that they don't have a fever, and that's all we need to do. And I will give you the example of my own household. When this all started, I started looking for thermometers. I found 2 or 3 thermometers. I have a 17-year-old and a 20-year-old. That's how old the thermometers are in my house. And so every time I've taken my temperature, it's anywhere between 92 degrees and 96 degrees on all 3 of these thermometers. So clearly none of them are working. So if you ask me to certify, did I take my temperature and did I have a fever before I came to work? No, I didn't. So I'm not sure that I would trust me to do that. So I think the certification has some value, but you have to also understand what kind of technology does the person, equipment does the person have at their home to really test for it. So it's something in the mix, but you can be asking what kind of symptoms. Do you have a cough? Do you have other flu-like symptoms? You know, there's a whole list of them that you can go through. And actually the CDC website has a really nice sort of Q&A about whether you should be tested or not. So all important things. And then we talk about COVID testing. Are you going to test your employees before they come back to work? I think there was some discussion about whether employers should have employees take an antibodies test, because then you would have an idea of what it would be like. Well, I don't think the antibodies tests are that reliable still at this point, so we'll have to see. Employees can, in certain locations, go get themselves tested. Here in Maryland, where I'm sitting this morning, I could drive down. I needed to have logged in. I could drive down and get a COVID test with no symptoms and no doctor's list or doctor's script, but it's not going to be instantaneous. So how are we going to do that? It's stuff you should be thinking about, talking with your insurance carrier about whether they're going to pay for those tests. All right, next slide. Remember though, any of that information you get from your employees is confidential. You know, we've got a whole alphabet soup list of rules and regulations that employers have to keep track of, and these include the Americans with Disabilities Act. That's very focused on the confidential nature of the information you're going to get. So if you decide you're going to take employee temperatures at the start of the shift, you might consider not tracking that information because that's confidential medical information. You can just do a yes or no. If your temperature is above 97 degrees, you come onto the work site. If it's 99.9, you're going to go home. So it depends on what you're going to want to keep. And the next step with all of this is, what are you going to disclose to other people? You should only be disclosing it to those on a need-to-know basis. And this entire time, you're kind of balancing who has an interest in knowing and who doesn't. If I call up my employer tomorrow and tell them that I have COVID, that I've tested positive, and I was at work the day before, I stayed in my work area, but on a couple different times I walked to the restroom, you, as the employer, have to decide who has exposure from my walking around and who really counts as exposed. And in my clients that I represent who've worked throughout this, who've had positive tests, every employee on that work site feels that they should have been told about the positive test. I will tell you that's not true. You really do need to make an assessment as to whether the person, there was any real legitimate exposure, and just walking past someone isn't going to do that. But this is where employees, I think, are getting really bothered by when these issues come up on the workplace. You can make a disclosure without identifying a sick employee. You can say, on the work site in this specific area, we had an employee who has tested positive. And so we ask that you monitor your symptoms, report any issues, but you can do it in different ways. Sometimes you have to just disclose the person's name. There's no way around that. Next slide, please. All right, so who's bothered by all of this and who's really got the regulations in place? That's the EEOC. They actually already had pandemic advice on their website back from H1N1 and swine flu. So that pandemic advice, and actually they have a really good FAQ section on bringing employees back to work, as does the CDC. And it's worth it as issues come up for you to take a glance at that. So the EEOC has indicated, hey, it's fine if you're going to do some screening. You can take employees' temperatures, you can inquire about symptoms, and you can send them home. You can even require doctor's notes. But at the end of the day, understand that there could be challenges to getting those doctor's notes. Now, I will say that for the most part, the employees that I've been dealing with haven't had issues getting a doctor's note, because so many of us are afraid to go to the doctor about other ailments. So the doctor's offices have actually had plenty of time to write the notes on this, but it could be a challenge. Your employee could come to you and tell you, I can't get this information from you. We also have to think about what disabilities are related or could be impacted by COVID. I'll talk about that a little bit later for recall. Next slide, please. All right, OSHA. OSHA is going to govern, and you in the construction industry know more about OSHA than my typical clients that I represent that are really office building type clients. And they have no idea what OSHA requirements are. Everything related to COVID is going to come out of that general duty clause that says the employer has to keep the place of employment free from recognized hazards and avoid serious harm. Next slide. Next slide. Oh, thank you. Sorry about that. All right, so what do you need to do to comply with those OSHA obligations? One is perform a hazard assessment. Looking at the jobs that you have on site, job by job, what are the areas where there could be basic infection? Where you're going to have too many people in an area? Where are many items going to be touched? OSHA prefers you deal with this through engineering, making sure your HVAC system is pulling air away and not just blowing it around if you're in an inside area. They want to make sure that you have the policies in place and that you are training your employees. That's going to be an important part of this. And that you have the PPE that's required, if it's going to be required, and the cleaning supplies that are necessary. Next slide. All right, we believe that this social distancing requirement is going to be in place for a while. I think there was some hope that maybe it was just a phase 1 or a phase 2, but unless and until that changes, I think for employers, you're going to want to be focused on how do we bring people to work but keep them apart in some way. And that's not always going to be doable, right? Some of it is limiting the number of people working in a certain area. Can you buy equipment that segregates? But at the end of the day, this concept that we would almost all work in plexiglass boxes to interact, I don't think is all that doable, and especially on a work site. And so while it may be in an office environment, you can rearrange the furniture or people work on alternate days, other places that's really not going to be possible. And so how do you really look at keeping people apart, and where it's not possible, what things can you put in place? And this is going to be really important because we employment lawyers think the biggest claims that are going to come out of this are OSHA retaliation claims. And that is employees who say that they feel their work site is unsafe and you terminate them for not coming to work. And so you're going to want to be making sure, and Jessica's going to talk about this in a little bit, that you're creating documentation around a safe work environment so that you can prove that you are meeting all these obligations. Next slide. So what about the reporting and record keeping requirements? We all know that OSHA requires logs. Do you have to log if you have COVID cases on site? And the answer to that is no. And the only places where OSHA has indicated that they would want you to report and to log COVID cases would be if you're a healthcare provider, correctional institution, or emergency responder. And that's because they believe that the transmission is really work related there. Now, there could be circumstances where you've got a lot of different people who've come up positive. If it's so many people that it is clear that it came through work, then you may have an obligation to put it on your OSHA logs. But a 1 or a 2, or people working in different locations in your work environment, it may not be the case that you need to record that. You know, one thing for a couple of my clients this year, they've had locations where they had a number of family members who were working in a particular location, and they all became positive together. They didn't become positive because of the work environment, they became positive because of their home life. So it's really kind of assessing on a case-by-case basis as to whether it needs to go onto one of those OSHA logs. And, you know, I think a big question is going to be, if someone tests positive for COVID, is that going to be workers' comp covered, or is the employee going to be able to sue you outside of that? We all know that workers' comp provides the nice way of capping the damages and the expense of it, and whether they're going to be able to go outside that. You know, there's a claim right now brought against Walmart by an employee who believes that by being brought back to work, they were infected. So I think we're going to see more to come on where the courts are going to go with those types of cases. Next slide. All right, masks and PPE. Most states and the CDC are recommending that everybody wear it. I believe Governor Northam is also requiring that people wear face masks or face covering at this point in time. I think that it's certainly, if someone thought that there had been an exposure, but not showing any symptoms, we would want them to wear a mask. But you're going to need to be thinking about how you train your employees on masks, how you make sure they're clean, and how you replace them. You know, the concept of what type of PPE you have to provide on a work site. You know, are we talking about something comparable to steel toe boots and, you know, an employee's obligation to have that, versus a respirator where the obligation really falls upon the employer on a work site? So I think there's more to come on where some of this PPE and face masks will fall. Next slide. And are you going to allow do-it-yourself options, or are you going to require employees to all wear one type of mask that you have given to your employees directly? I think these are all decisions you should be making early on in the process so that you can keep consistent. I think it's been difficult over time to acquire PPE. I know, though, that I was able to get a box of 50 masks just from, you know, for $50, it seems. But I think it's easier if you're going to allow your employees to bring their own type of equipment to work in terms of a mask. Next slide. All right, next slide. All right, now I'm bringing everybody back. I've checked their health. They're wearing the stuff that I need them to wear, and now they're coming on site, or I've told them they have to. And so these are some of the issues that we're seeing. Do we need to pay our employees for the time that they're spending getting that health screening every day? If it's de minimis, you do not, but if there are long lines to get health screened, it's like the donning and doffing rules, right? That you may have to pay for that person to put on or the PPE or to be health screened. What about reducing pay? The economy has hit most areas, and for many employers, there's a need to reduce compensation. Now, certainly you can't do that if you're on a job that has a prevailing wage, but otherwise you would have the right to change the rate of pay. In some jurisdictions, there's a notice requirement for that. So here in Maryland, we have to give 1 full pay period of notice. In Virginia, there's no notice required. And you just want to keep in mind as you're moving around compensation or hours that people are working, that there can be issues with exempt employees on that. Then you're going to need to decide, am I going to pay hazard pay? That's not required now, but I will tell you that as I have clients who have employees rolling back into the workplaces, there are a lot of people who do not want to come to work and who would like to stay on unemployment for a little bit longer. So how do we motivate them to come to work? We'll talk in a minute about unemployment, but attendance bonuses is one way to do that. Just remember that when you give bonuses, that may impact your overtime calculation rate. And I think there's always issues with hourly workers working from home because you don't know how much they're really working. Next slide. All right, so they return to work. How are you going to manage if they took time off due to a furlough or leave? How do you manage any need for additional leave once they return, be it either sick or vacation? These are just issues to think about, and the ideas are there on the slide, but it can cause problems if your employees have cashed out all available paid leave that they have. Next slide. All right, don't forget about the FFCRA. I feel like this was hot news back in March and April and has gotten a little quiet. But remember, if you have under 500 employees, you are going to be subject to the Families First Coronavirus Relief Act, which provides 2 weeks of paid sick leave for exposure to COVID symptoms, needing to quarantine, and or EFMLA, which provides paid time off for taking care of children. And there's a lot more information out there about that, and we have a lot on our website at mslaw.com. So I'm not going to waste time getting into that, but I expect that as you bring employees back where they have concerns, they know full well that this type of leave is out there. Next slide. All right, we're seeing a lot of increased anxiety, mental health conditions. Are people going to be asking for additional time off? I think most people are coming back. They want to come back to work. They want to make a living, but know that there are these pockets still available of types of leave, protected leave or paid leave. I can tell that the mental health issue is on the rise because I noticed on the ads on the television. Last night I was watching the news. There were 2 different ads, one for a meditation app and one so I could receive psychotherapy through telehealth. So clearly they've assessed that there's going to be this need in the marketplace, and you may see that with your employees. I think you may also be seeing a lot of requests for accommodation from those employees who may have an underlying health condition and or are over 65 and are concerned about the impact in that age bracket in 70s. And so be thoughtful that you are not discriminating against them and assuming that they wouldn't want to work because of an underlying condition or due to age. But at the same time, if there's a request for an accommodation or a request for a different work environment, while you may not ultimately have to give that, you are going to have to go through the interactive process and discuss with them whether you can really give that accommodation or not. Next slide. All right. This slide is basically what I just talked about. You just don't want to be making assumptions about people's ability to work or at being over a certain age at being an increased risk. Next slide. All right. Unemployment reporting. Some employees do not want to return while they are able to get that additional $600 from the federal government that's going to run through the end of July. you are able to report to most state unemployment agencies that there is a job available and they are refusing recall, so that you can stop those benefits. But you need to put in writing to those employees so that you can try to use that to make sure that you aren't paying out unemployment for employees that you were willing to recall. You want to make sure that you have all of this in your policies and your handbooks, and make sure when you're looking at making these decisions, they're really based on objective work criteria. Next slide. All right, employees are going to have a ton of ongoing concerns. Just know that all of these different leaves and fear of getting sick, all of the stuff that Jessica's going to talk about is some of the stuff that's going to make sure that employees understand that the workplace is safe and that this generalized fear of getting sick isn't sufficient to stay out of work. Next slide. All right, I'm not going to go through the practical takeaways because I've gone through my time, but they're on the slides and we can always come back to it. Turning it over to Jessica.
Good morning, everyone. I will try to be quick. My point, I think Suzanne really did a great job at outlining some of the fundamental OSHA considerations with respect to employees. What I want to do is segue into how does that impact on construction job sites. And trust me, I have been on plenty of job sites. However, I do recognize that I'm speaking as a lawyer. So a lot of these issues, concerns, and concepts need to really be taken inside, applied to each type of job site, each type of contractor. And you really need to look at these issues individually and apply them to how the practical considerations per job site, per trade, et cetera. And so what I'm going to address is, your safety plan, some job site cleanings, and other job site considerations you may want to consider in reopening job sites or moving forward. A lot of states have not closed up job sites. They've kind of muddled through on a day-by-day basis, and we've helped clients try to adjust as these things are moving. So if you can hit the next slide, please. Safety plan. Most job sites require them at different tiers. They're just to, as you know, they address site-specific physical and health hazards that could harm workers, procedures to prevent accidents, and steps to prevent accidents. Having read plenty of safety plans, while they are general in nature, they likely do not cover the type of hazards and risks posed by COVID. I think it's an important time to take a look at existing safety plans on existing ongoing job sites. And as you move forward with new construction, consider taking a pen to your job site plan or safety plan that you reuse and adapt to new job sites, and look at how they can be amended. These are required at most tiers. If you're a general contractor, you're going to require your significant trades to also have safety plans. So in contracting with if you're a general contractor or a major subcontractor who has second tier subcontractors, you're going to want to look at these issues at the contract stage. When you require safety plans, I think it's important to now in this new world, have these safety plans address COVID-19 hazards. Next slide, please. So some of the things you may want to consider in amending your safety plan or is developing a COVID-19 exposure plan to include as part of that safety plan. So, and remember, when I say developing, general contractor has an obligation to develop an exposure plan per the overall project site, but you may require subcontractors to develop a similar I know that jobs that we have with respect to soap, water, and hand towels being available, but these are issues that need to be addressed specifically in your safety plans. You might want to consider requiring and enforcing face coverings and masks and social distancing on sites and in trailers where possible. And you're probably going to want to get into, the type of face coverings and masks that are going to be required, who's going to provide them. Answer these questions up front so it makes for less of an issue when you do open the job site, or when everybody gets back to work, or you start construction on a new job, that all of these issues are addressed already in the safety plan. With respect to types of masks, the reasons why you want to, to the extent possible, call out the type of mask required. One, there's trade industry masks that prevent, dust exposure and chemical exposure. Those are different, obviously, than the type of PPE mask we're talking about with respect to the transference of COVID-19. There's a lot of press in there about effective masks and non-effective masks. So these are some considerations you're going to want to take a look at in amending your safety plans. Just like, steel-toe boots, in some industries and some practices, the type of boot you're required to have is different. It's the same with masks. So these are issues you're going to want to address. Social distancing, again, that's an issue that's going to be largely by trade. You can develop something in your safety plan that talks about social distancing generally, but as you know, on a construction site, that's not always going to be possible. So again, I think when you push down safety plan requirements, I think individual trades need to look at social distancing, what they can do to limit direct contact on a particular job site. You're going to want your safety plan to require enforce reporting at all levels, meaning if a second tier subcontractor develops a COVID or COVID-19, where that gets reported and how that gets up the chain of command so that the general contractor is aware of it. You're going to want to have your safety plan address limiting sharing of equipment, also address cleaning procedures where possible. And you're going to want to try to minimize sharing of vehicles, equipment, drinking coolers. I know that there are practical considerations, particularly in markets like DC and New York, where parking is not easy, and there's a lot of ride sharing going on. There's a lot of vehicle sharing. Again, these are issues you have to look at a job to job basis to determine what you can do to minimize it. If you're on a job site in the middle of nowhere and everyone can drive separately, that may be the way to go. You're going to require particular supervisors to be familiar with and enforce your COVID-19 plan. And you want those supervisors to be able to answer COVID-specific questions for employees. And that's probably the key. And that's where training comes into play. Training on the person who is a supervisor identified at each tier level to be able to answer questions and to enforce these rules is going to need to be trained himself or herself, but able to train others in, the proper procedures in reporting and the proper procedures in, cleaning and face masks and social distancing. All of these issues, if you address them properly in your safety plan, should mitigate some of the COVID-19 spread if it does hit your job site. Next slide, please. Okay, job site cleaning. This goes hand in hand. Most subcontracts require job site daily cleaning. In fact, I put the AIA standard A401 2017 language about job site cleaning in here. Most contracts, as you know, just require, pick up your rubbish, broom sweep it. I've seen some contracts that get a little more particular in what's required by trade. On new job, you may want to consider amending your current contracts on ongoing jobs or increasing this language to cover COVID-19 related cleaning for new job sites. These old paragraphs do not address COVID-19 hazards. It could, keep in mind, I've had 2 job sites where there have been COVID exposure. And I'm thinking of one particular job site where 3 individuals came down with COVID. It required a shutdown of this particular field office and a hazard company to come in and clean. It was thousands of dollars. Representing the sub, there was an opportunity for us to pass that cost up. As a general contractor, if you address these cleaning requirements out of the gate, if you address responsibility out of the gate, you may not be hit with this charge. So requirements should be part of the contract. Next slide, please. Okay, so what are some of the things you might want to consider either amending your existing contracts or amending ongoing contracts? Require daily cleaning and disinfection of job site trailers, break rooms, lunch rooms. You're going to require shared equipment and vehicles to be cleaned in between use. So if you have particular, whether it's a job site type of equipment that's being shared between subcontractors, there should be a requirement that it's clean and disinfected in between the passing of that equipment to the next trade. You're going to want to talk about daily disinfection or a transfer disinfection in your contract. Require more regular disinfection of restrooms and refilling of soap and hand towels. Remember, this is an OSHA requirement. If you do not have potable water, soap, hand towels, and disinfectant, it might be something you want to add to this, that is an OSHA violation. And I have seen this issue come up on job sites at post-COVID-19 where a job site it's a train station, did not have potable water, there was no hand sanitizer, and there were threats about employees not coming to work and making claims, OSHA claims. And when the employer said, well, we can't get any hand sanitizer, we can't. When you start drilling down, it's amazing how a little bit of effort can get these soap, hand water, everything to a job site pretty quickly. So this is something that should be done on a regular basis, and it should be pushed down on your subs or whoever's responsible for bringing in, if it's a general contractor, bringing in the restrooms and the facilities, that the obligation is there to clean them, disinfect them, and refill them. You're going to want to require special cleaning and decontamination of areas if a worker or visitor is confirmed positive for COVID-19. So that might be harder on if it's a job site, a very large building, or who's going to be responsible for the cleaning and decontamination of an area. It may not go down to your subcontractor, but it could extend to the subcontractor's trailer. So these are things you may want to consider passing down in your contractual obligations to subcontractors. You're going to require daily record keeping of areas cleaned and the products used to disinfect. And this will go to what Suzanne said, is presenting and having a job site where employees can feel that they are safe or safer from the transference of COVID-19. It'll also go a long way if there's some type of OSHA complaint or violation to establish that you have taken the requisite steps to ensure a clean job site and used products that help to disinfect COVID-19. Next slide, please. So, and this is to wrap this up. There's other considerations you may want to undertake, and these are safety meetings. Start addressing COVID-19 issues at your toolbox talks, which should be held by phone if possible, or at least at a safe distance. COVID toolbox talks, and I often in construction projects where there's been a complaint or an accident or an injury, one of the first things as a lawyer is I ask for all the safety meeting logs, all of which do usually, and if they don't, they should cover the topics covered. And I know, for instance, things like sunblock and water and some basic health hazards of a construction site are addressed routinely. I would add COVID-19 to your toolbox talks as a subject matter, even if it's just a constant reminder to wash hands, social distance, how to clean your masks, and basic hygiene. It's also an opportunity to find out if people are following the new cleaning procedures and reminding them of the cleaning procedure requirements, and to reaffirm the safety plan information regarding COVID-19. And again, I think it's very important during these times to maintain safety data sheets of all disinfectants, cleaning of project sites and shared surfaces. this is something you may want to consider doing on each job site. So that's basically it. I kind of sped through it because I want to leave time for Tom, but I can answer questions and Suzanne can answer questions too.
Okay, I'm going to be brief, but the points that I make, I think, are extremely important. First, you want to have a mindset going into any project about your contract. Every state is different in applying contract law, but there's no state that is more stringent than Virginia in saying the contract means what it says. And you don't get around it simply because a provision is unfair. And so there's nothing more important than carefully reading your contract and noting right up front, what are the things in this contract that can screw me out of getting paid for the work I'm doing? We have seen recently owners trying to require contractors to certify that their employees don't have coronavirus, even trying to get the contractors to agree to indemnify the owner if the contractor brings employees to the site that have coronavirus that is spread to others and causes any problems. So is that acceptable that they require that? The answer is generally no. The owner can inquire to the types of things that Suzanne and Jessica were talking about regarding temperatures. Have you been exposed to somebody with coronavirus and so forth, and require employees to answer those questions. But as far as certifying that the employees don't have coronavirus, and much less requiring a new, I'm talking about in the middle of the project, a new indemnification requirement, that is generally not accepted. There's nothing in most contracts that would allow an owner to do that, or that would allow a general contractor to require that of its subcontractors. But again, everything depends on the actual language of the contracts. It could be that in most contracts, there is a requirement to have a safety plan, comply with a safety plan. You might have to comply with the owner's safety plan. A subcontractor will probably have to comply with the general contractor's safety plan. And if that safety plan can be interpreted to require these types of certifications or additional measures related to COVID-19, then you would have to do it. But the general safety plan that I've seen in most contracts is not going to permit a requirement for this type of certification. You do have to be aware. This last week on an owner's project that was, the whole project shut down because one of the subcontractors had all of a sudden 5 employees who tested positive for COVID-19. And so that gets into the question of, well, who pays for all this? Next slide, please. When you have to have your employees observe social distancing and spend extra time cleaning, obviously that slows down productivity. And the question is, okay, time is money. Who's paying for that? And again, the answer to that question will lie in your contract language. In the AIA contract, there is I'm referring to the general conditions A201. There is a provision that allows for an extension of time if there are problems that arise that are beyond the contractor's control. That probably, although it doesn't specifically address pandemics, but it probably allows the general contractor to get an extension of time. But that extension of time doesn't necessarily entitle the contractor to additional money. If you take away nothing else from what I say, I want you to remember that the most important thing to keep in mind for contractors to make sure that you don't lose the possible right to get paid for the additional cost of dealing with the COVID-19 and the delay that results in on your project is to observe the notice requirements of your contract. Next slide, please. So the force majeure clause in your contract may apply, may cover COVID-19, or it might not. It all depends on exactly how it reads, but that's something that you need to read carefully. Virginia is, for contractors, the worst state for having you inadvertently waive legitimate large claims. And that is done through the notice requirements. If there is a requirement in your contract that says if you have reason to believe that you are entitled to additional compensation because of any change in the scope of work or any delay on the project, you must give notice of that in writing to the owner within 48 hours of the event giving rise to that potential claim. Otherwise, it's waived. But that means if you give notice 49 hours after the event arose, you have just waived your claim, no matter how legitimate it would have been or how large it would have been. And so there's nothing more important to keep in mind than what are the actual notice requirements in my contract. There is generally no downside to giving notice of a potential claim or potential for delay that you decide not to pursue, that turns out not to be something worth pursuing. But if you fail to give the notice, then generally you are not going to be able to pursue it. And then you need to keep in mind, is the owner going to be able to pay? I have a project for a large general contractor for a huge multi-billion-dollar company owner that the owner shut down the project and said, we're not going to be able to pay you. Fortunately, the general contractor saw that coming and read its contract carefully, knew what it had to do to preserve its claims, filed a mechanics lien in time, and then was able to negotiate with the owner to actually get paid, even though the owner had said they weren't going to get paid. But there will be, without doubt, delays related to COVID-19 and disputes over who has to pay for that delay. And most likely the specific language of your contract is going to determine whether you get paid, and whether you've given the notice is going to determine whether you have preserved those claims. So with that, I will turn it over to the questions that I think, Gordon, are you going to tell us what questions we're answering here?
Absolutely. Absolutely. I appreciate that. Thank you all very much for for presenting that. Tom, I think this one might be for you, and you sort of were touching on it, but I just want to kind of touch on it and just kind of read it because you may have a different answer on this. And it's from a supplier who says that several sites locally have been temporarily shut down due to a COVID positive person being on the site. This is causing delays in substantial completion. If my company is the one who shuts the project down due to me or my team testing positive for COVID, are we to expect penalties?
Well, so there are, under contractual law in Virginia, there are no penalties, but there are financial consequences. Okay? Penalties are not enforceable if in a contract, but if you do something that breaches a duty that you have and that causes somebody else to incur expense, chances are you will be liable for that. But keep in mind, it's not a what lawyers call a strict liability standard. Anybody can be carrying the coronavirus and not know it. And so if I have it and I give it to somebody else, but I didn't know I had it, didn't have any reason to be taking different precautions than I was taking, I'm not going to be liable for the consequence of this other person getting the coronavirus. If I have been, if I have failed to observe normal safety precautions, and that's why I introduced the coronavirus to your work site, I may well be liable for that. And what is the reasonable expectation of observation of safety requirements is evolving. I mean, a couple of months ago, it would not have required wearing a mask on the site. Now it certainly does. So the answer, unfortunately, is it depends on the circumstances, and it will also depend on your contract. Unless you as the supplier failed to take reasonable precautions to avoid introducing coronavirus to the work site, it's unlikely, in my opinion, that you will be held liable for that.
Tom, thank you very much for that. So the next question I think is probably going to be for Suzanne. If we only ask yes or no question format for health screening, does that mean it does not become a confidential health document and does not need to be treated as such? For example, if we have a form that asks, does an employee have a temperature above whatever, with a yes or no response?
So if we're keeping it in document form, specific to an employee, then yeah, I think we have to keep it confidential. But understand, all that means is if we've got a folder, a personnel folder that has generally all their information in it, we just have a second folder that says confidential information and we put it in that folder. Or we keep it confidentially on a computer system. But anytime we're creating records, even if it's just yes or no, then that's got to be treated confidentially, unfortunately. The ADA and the EEOC are pretty broad on that.
Very good. I think you may have addressed this one. And so this question basically says, does your statement about positive cases not being considered recordable for industries aside from the medical take into account OSHA's recent memo that came out regarding this?
Sure. And that's a great point that was raised. So if you, I don't have the slide up, but the slide basically mentions that if you're in one of the industries specific where there could be transmission in your workplace, that's going to be an OSHA recordable incident, or if there's a large number of cases. And so if it's just one person, no, that's not a recordable incident. If you had two sort of in different locations at your facility or work site, that's not going to be recordable. What you're going to look at, and I appreciate the participant bringing up that memorandum. The memorandum does a great job of laying out for you the questions that you need to look at to determine whether there might have been transfer at your work site. There's so much community spread at this point that the assumption is that the person got it not on your work site. So there would need to be something more to indicate that they had. And that really is this greater number of people, typically in a certain area, who become positive. But again, that's a really good resource.
Great, thank you. Next one is regarding FMLA. FMLA is 50 or more employees, but the COVID acts are for 500 or less employees. Does FMLA kick in even though the company has fewer than 50 employees?
Another excellent question on all of these kind of paid leave laws that went into effect with COVID. So typically FMLA, the Family Medical Leave Act, is reserved for employers with 50 or more employees that they have obligations to give 12 weeks of protected job protection. What the EFMLA does, Emergency Family Medical Leave, it kicks in for any employer with under 500 employees. So out the window is the 50 employee mark. The only thing that they're looking at under EFMLA, and understand it's for a very limited type of emergency leave, EFMLA is only if you are taking time off to care for your children because there's no school or there's no daycare. And the employee is entitled to up to 2/3 of their pay per day to a cap of $200 a day. And that's what you're entitled to. That's the only part of the EFMLA that applies to people under 50 employees. And remember that that EFMLA money that you spend, you can get a tax deduction on your payroll taxes. So it's dollar for dollar what you pay out, you are able to get an immediate credit on. So that's something to be thinking about in terms of the cost of it. Something totally unrelated, but if you are receiving PPP money and you paid for that EFMLA with PPP money, you may not be able to make that payroll deduction, but you should talk to your accountant about that. I'm not a numbers person.
Very good, thank you. The next question is regarding masks and the governor's recent directive that takes effect tomorrow. The person asked, they thought they heard Tom just say masks are now required. Wanted to see if you could expand on that a little bit. Is that required indoors and outdoors, or just indoors, or what do you know of that at this point?
Right. So what I was referring to is not the governor's decree that you must wear a mask in public buildings. His recent pronouncement involves, but my comment went to the question of what is the standard by which you will be judged as to whether you were acting reasonably when you may have introduced coronavirus to a work site and shut it down. And so that's a different standard from whatever the governor says. It is what the lawyers call the reasonable man standard, and it's informed by what is in the press, what people generally know, and what has become the customary practice for trying to avoid the spread of coronavirus. And so I think now you would have no problem proving in court that as of today, it was generally accepted and the recognized practice for safety that if you are going into a building or a work site where there are other people that you may be coming in close proximity to, you have to have a mask. And if you go in and it turns out you have coronavirus and you weren't wearing a mask and people you came into contact with got the virus, you are probably going to be liable for that.
Can I jump in here real quick? And I think this is important, and I'm tracking it for a few of my clients that have national construction practices, or not practices, site jobs. Keep in mind that the requirements of, I know this is a Virginia group, but I know that, it's not just the governor's edicts, it's also going down to the local level. So we know in some areas of the United States, you have the governor's orders, then you have the county's orders, then you have the city's orders. And honestly, they sometimes seemingly flow together, and other times they contradict each other. We are helping our clients manage that. But to Tom's point, and safety standard, and if you're looking at it on a job site, the easiest thing to do is establish a safety practice through your job site requirements that requires something like this. It's a fairly simple requirement that can slow, and we know, at least from the data that's out there, it will slow the spread. Despite what because the governments are changing their edicts, it's probably a safe thing to just require, and that way you're not going to trip over a change in the law from one location to the next.
It's a great point, Jessica. I really appreciate you bringing that up. And, even in Virginia, the governor has said that localities in Virginia have the option to be more restrictive if they want. So that's something just to be aware of, depending on where your job site is. Next question. How long does documented health screening records need to be maintained?
All right, that's me. That's 6 years under HIPAA, which seems like a long time, but it's 6 years.
Great. Next question is EMFLA also applies to employees who have worked for you for at least 30 days, while standard FMLA requires 12 months of employment before FMLA kicks in. Is that correct?
Correct. So the way that EFMLA is going to work is it's anybody who's been on your roster for greater than 30 days or right at the 30 days. You can use the same paperwork that you use for FMLA. For EFMLA, just the reasons for it are very different than what was historically done. Kind of an add-on to that EFMLA question, ESPL, which is that 2 weeks of emergency paid sick leave that we talked about a little earlier. It's in the same legislation as the EFML. It only requires that you be on the job roster 1 day before you're entitled to that benefit. So it's 30 days for EFML, 1 day for ESPL. So a lot of boring little acronyms.
Boring, but important. We appreciate that. So those are the questions we have at this point. If you still have a question, you can certainly type it in, or you see here on the screen, you have the emails and phone numbers of our 3 panelists who are here today. So you can certainly talk to them and shoot them a note or give them a call. I'm sure they'll be glad to take your call on any specific follow-up questions. Suzanne, Tom, Jessica, thank you all very much for your participation today. Very informative information. The situation is always fluid and changing. I'm sure we're getting tired of certain words, whether it's COVID, coronavirus, or fluid, or whatever else may be, but these are the times we're in. Next week's presentation, also by Miles and Stockbridge, is going to be focused on the impacts of legislative changes in Virginia. Significant changes happened in Virginia this past legislative session that were going to be impacting contractors, less on and a lot around labor and employment law. So we have some presentations on that and how to prepare yourselves and your firms for dealing with those kind of changes. And we look forward to you all participating in that, and we'll have the registration site up, if it's not up already, on our website soon. Any other questions today?
Thanks, Gordon.
Thank you.
Dan, Thomas, Jessica, thank you all very much. Greatly appreciate you all's time today. Thank you.
All right.
All right.
Bye-bye.
Okay.